Welcome back to this week's episode of The Emily Show, y'all. I can't believe it's August. Court is full tilt, and then it's going to start to slow down. Like the fall is always crazy, and then we'll get into that lull as none of the attorneys want to do anything between like November and January. Some of them are going to have to, but the attorneys in today's cases have been quite busy. There's lots to update in the YSL Young Thug prosecution out of Georgia, because I don't know if that trial is ever going to get back on track. Jurors were originally scheduled to be back as I record this today, August 5th, but they're in the middle of a lot of motion hearings, including a motion to dismiss. The defense is alleging some Brady violations, and we're going to have to talk about that. And then an attorney, former attorney that's probably not thrilled to be going to court at the beginning of August is Tom Girardi, because his trial is just about to get underway in federal court in Los Angeles. I'm going to talk to you about what the prosecution is looking to show in this trial. They think it's going to be about a 12-day trial maximum. It might be a little shorter than that. So we're going to go over their trial memorandum and some of the rulings the court has made briefly, so you know what's going to be shown at that trial. But here's a quick TLDR. It's a lot of what we already know from Tom Girardi, but some interesting aspects as to what I think his defenses will be, or at least I hope they're interesting. I find them interesting, and hopefully you will too. So we should probably just get into it. Welcome to The Emily Show. I'm Emily D. Baker, the internet's go-to legal analyst and big fan of the cursey words. I've been a licensed attorney for over 17 years. I'm a former prosecutor, and I break down the legal side of pop culture and entertainment stories we can't stop talking about. We should just get into it. Let's go. Thank you to today's sponsor, Green Chef, which is the reason I regularly have dinner, because life is often busy. Green Chef delivers easy to prepare chef quality meals right to your door with a huge variety of not just menu options, but different eating routines. You can pick from vegetarian or vegan to protein-packed, balanced, or Mediterranean. There are tons of options at Green Chef. If you're looking to take your clean eating routine with Green Chef to the next level, they've got an offer for you that has 2 times the support. Green Chef's offering its healthiest menu items ever and access to top-rated gyms and fitness studios worldwide from ClassPass. That's right. For a limited time, Green Chef subscribers will also receive 50 credits to use at ClassPass. That's about a month's worth of membership. So if you're ready to try it all for yourself, go to greenchef.com/EmilyBakerClass for 50% off your first box and 50 free credits with ClassPass. That's code EmilyBakerClass at greenchef.com/EmilyBakerClass and get 50% off your first box plus 50 free credits to ClassPass. Find out for yourself why Green Chef is the #1 meal kit for eating well. Let's get back to today's episode. So to Georgia first with the YSL Young Thug prosecution. If you've not been following this case, it is an 88-page RICO indictment, ultimately charging 26 defendants. There are only 6 of them on trial right now with Young Thug. Jury selection started in January 2023. The case didn't start going to the evidence phase until November 2023. And here we are in August 2024, and oh boy, so much has happened. It's already the longest trial in the history of the state of Georgia, but that's not all, because the judge that has done this case up until, mid-June has been recused. There is now a new judge on the case. Some of the evidence from after the judge's recusal is not going to be allowed in. We'll talk about that in just a moment. And there are ongoing motions, even as I'm recording, regarding potential Brady violations that the judge sitting on the case now is taking very seriously. They are 5, I believe, witnesses into the hearing today. And that hearing, the court has already indicated, is going to go into the day on Tuesday, August 6th. So by the time this airs, I don't know if there will be a ruling on that or not. But when there is, I will send out a note in the Law & Order app and hopefully cover it on a live stream soon. It's a very busy week of streaming up in like Emily land, because we have hearings in the Corey Richards case out of Utah and a big hearing Friday in the Karen Reed case in Massachusetts. So if you're like, Emily, Is this week chill? No, this week has zero chill. It already has zero chill. But if you have the Laundered app, you'll know when I'm going live. So let's catch up on what's going on in the Young Thug case and talk about the attorneys sharing with the court that there may have actually been 2 ex parte hearings. Yeah. Remember when the judge got recused off of the case, when the whole thing went down, one of the defense attorneys was held in contempt. The judge was going to put him in custody. And then there were motions to recuse the judge. And the reason the judge was recused was not because of the ex parte conversation that the judge had with prosecutors and a witness and that witness's attorney. It was because of how the judge handled the recusal motions. And that's what the court found objection with and ended up taking the judge originally seated on the case, Judge Glanville, off of the case because of the recusal motions. But the overarching issue of ex parte hearings in the judge's chambers with a witness on the case, Mr. Copeland, you will hear me talk about a lot as we move forward because there is more information coming out about that, allegations that the transcript is not complete, that more happened in that hearing that the defense still is not alerted to, that that witness made statements that should have been disclosed and turned over. And the prosecution is still doubling down that there was nothing wrong with this at all and that the court shouldn't find a Brady violation. And to support that, they are bringing in just about everyone who was in that ex parte hearing to testify about what they remember. And the conflicts about what they remember are substantial. And then there's a side issue about whether or not the prosecution was talking to the witness when he was represented by counsel without his own counsel present before the ex parte that we've talked about. So when we say issues, there are issues in this prosecution, and the defense has made so many motions to dismiss this case. It's so many motions. So August 5th, the court was supposed to resume with jurors. That is not happening because of the motions. Judge Glanville was recused. Judge Whitaker is the new judge overhearing these motions. And Judge Whitaker has been very active in the motion hearings from what I have watched, asking witnesses questions. And it is confusing, partly because of how many people are involved. I think partly because the judge is new to the case. So they're talking about hearings with like 4 people and a witness will be like, and then she said this and the judge is like, time out, she who? Because we're talking about like 5 different people. And it is not always easy to follow. But Judge Whitaker did grant Young Thug's motion to strike all the rulings and proceedings that happened after June 12th. The jury wasn't in very long after June 12th, but that's when the motion to recuse Judge Glanville was made, and it was determined that he should have sent that motion to another judge, and that's why he was recused. So everything that happened from June 12th forward in time until Judge Whitaker took over the case is being stricken from the record. And that includes some of the testimony of the witness that all of this is surrounding. The witness that was in chambers with the judge, the witness who seemingly wanted to plead the 5th, but was given use immunity and then was told they couldn't plead the 5th and then was told they'd be in jail if they pled the 5th, told they'd be prosecuted for perjury if they perjured themselves. And in all of that, it seemed that this witness was saying, well, I'll just say I did everything then. I'll just say I did it. I did it. I have never felt more old than watching these proceedings today and seeing one of the attorneys that was in the in-chambers ex parte hearings referring to a homicide as a unaliving. I was like, what in the internet is happening here? Because all the times I have been in court, and granted, I am old, but all the times I have been in court, the conversation around homicides are, calling it either the death, the homicide, the murder. But when we got to somebody on the record in court, an attorney on the record in court referring to a murder as an unaliving, I was like, I am too deep in internet talk in court from an attorney. From a witness, I don't know if I would feel the same way, but from an attorney, it made me feel so old. Ugh. Anyway, continuing on. what I wanted to go through a little bit today is one of the co-defendant Kendrick's motions for mistrial. This is a supplement to the motion that starts to bring light to a potential second ex parte hearing, in addition to the June 10th ex parte hearing that most of the conversation has been about, and a lot of the testimony in today's proceedings have been about. This was filed on July 31st at 7:15 a.m. It's a supplement to defendant Deamonte Kendrick's motion for mistrial. And it says that Judge Glanville making outrageous allegations against members of the defense team in the present case, quote, but I think it does in some way outside agitators and everybody else who I think are trying to influence. So there have been numerous allegations about Judge Glanville's behavior in this case, not just in the motions for recusal, but in all the motions for mistrial, of which there have been numerous. Some of them have already been dismissed, but there are motions for mistrial ongoing. And this supplement helps kind of inform what everyone is testifying about and arguing about in the ongoing motions this week. This is a supplement, so they're going to hearken back to their original motion that I have not covered, but the supplement covers it really well, so we are going to zoom through it. It says that the third ground argued in Kendrick's motion for mistrial is that Kendrick's due process rights were violated relating to the 14th Amendment due process violation, relating in part to Chief Justice Glanville's wrongly coercing Copeland to testify. Further evidence of the state and Judge Glanville's violation of Kendrick's due process rights have just come to light, either way. Yesterday after court, Kendrick received a rough transcript, Exhibit A, of an additional secret ex parte meeting with Judge Glanville held on Friday, June 7th. This is the Friday when the judge put that witness into custody and basically said, wait out the weekend, we'll talk to you again about whether you're going to plead the fifth after you have use immunity on June 10th. So this is another potential ex parte that the defense is complaining of in their motions. The rough transcript was helpfully provided by this court to defense counsel. A reading of the transcript highlights that which has been obvious to all observers except for Kendrick's counsel for the past 19 months. I don't know why it wasn't obvious to Kendrick's counsel. Judge Glanville has been willfully biased and acting as a member of the prosecution team since the inception of this case, is their allegation as the motion continues. They go on to say Kendrick's counsel takes no pleasure in alerting this honorable court to the situation, but client obligations require it. Due process requires a fair trial. And then the defense is going to tell you why they think that their client has not gotten a fair trial. But I think at this point, the proceedings have gone on too long that we could see a dismissal as to just one or two defendants. At this point, we're in for a penny, in for a pound, right? Everybody's in it in these motions. And when the hearings have been taking place, every defense attorney has the opportunity to ask questions of each of the witnesses. The witness goes on to say, it's not a fair trial when in an ex parte meeting, Glanville, Love, Hilton gossip like yentas over 13 pages about attorneys. I think it's Sterrett, Melnick, and Steele. So the gossiping like yentas came in very early in this motion. So I'm curious what the subject of the gossip is, but don't worry, you're going to be brought in to the cackling hens, as it were, that are being alleged here. So the defense motions have not lacked colorful language in any of them, and I can understand why the defense is so frustrated with all of this, not to mention the defense attorneys have been in this trial for like 18 months. It's wild. It is not a fair trial, the motion continues, when in an ex parte meeting, Glanville, Love, and Hilton, by the way, is one of the other prosecutors, attack attorney Bumpus for allegedly hugging Kendrick and stating she is incapable of representing Copeland. Attorney Bumpus is the stand-in attorney for witness Copeland, who was present during these meetings because Copeland's attorney was unavailable or on vacation or something don't worry, Copeland's attorney has testified, and it seems like might be testifying again in these ongoing hearings. It goes on to say it's not a fair trial when in an ex-parte meeting, Love lies to Glanville. This is the DA lying to the judge, allegedly, about an email she received from Attorney Melnick. Attorney Melnick, and if y'all are like, Emily, we need a chart. Yes. Attorney Melnick is witness Copeland's attorney. Attorney Bumpus was the stand-in attorney. Love and Hilton are the prosecutors. Glanville is the former judge. The motion goes on to say it's not fair when in an ex-parte meeting, Glanville starts talking about, quote, outside agitators, stating, quote, my comments today were predicated on there's a lot of stuff that's going on in the background, and it shouldn't have anything to do with anything with y'all's case or you all's case. It really shouldn't, but I think it does in some way, outside agitators, and then there's nothing else in the motion. It just drops. It goes on to say, it's not fair when in an ex-parte meeting, Glanville and Love have the following outrageous conversation. And this is a transcript typed into the motion. Court, but I think it does in some way. Outside agitators. Miss Love, that too. The court. And the way it indicates, it looks like they're talking over each other a little. The court and everybody else who I think are trying to influence Miss Love, that is absolutely happening. I don't know if this is outrageous or not because I don't know what the fuck they're talking about. But it seems that the defense believes in context they are talking about defense counsel. But we will see. It goes on to say it's not fair when Glanville, Love, and Hilton have this further discussion. And this is the judge and the two prosecutors. If they are having a discussion about the case outside of like, I have a family emergency and I'm not available tomorrow or something, none of that should be without the defense attorneys. And it goes on to say, Miss Hilton says there's a lot going on. Miss Love said there is a presence. Yes, that is all I'll say. The court says, I mean, but I see it from just being in the courtroom and tracking. Again, are they talking about the substance of the case? Maybe, but I need more context. But there's going to be lots, I'm sure, of context over the hearings happening today and tomorrow. So next week, we will probably be able to swoop back to this topic and see what happened. The motion goes on to contemplate how many violations of the Georgia Code of Judicial Conduct does it take to get a mistrial with prejudice. With prejudice meaning the case cannot be refiled. They go on to make an analogy saying, this case is like an old house that the present honorable judge is tasked with renovating. Every time a piece of pasted up wallpaper is removed, more rot is found hidden underneath. The motion goes on to say no Herculean effort by the present court can fix the due process violations of the last judge. The house must be torn down, or this house must be torn down. A mistrial should be declared and retrial barred due to prosecutorial and judicial misconduct that has goaded Kendrick into the present motion. I don't know if goaded is the word I would use there. Forced, but okay. It closes with Kendrick respectfully requests this honorable court to declare a mistrial based on at least due process violations of Kendrick's constitutional rights and signs it the 31st day of July. Again, this is an addendum. This is a separate motion. This is not a full motion. And it cites the partial transcript, which is attached. And it seems that the only individuals in the room at this point are Attorney Love, and I'm zooming through the transcript if you are listening, Attorney Love, Attorney Hilton, and the court talking about what to do with a witness. But even at this point, the witness and the witness's attorney aren't present. And what I think we need to do for the context is take a look at a bit of this transcript and see what the judge and the two DAs are talking about with regard to this witness and the witness's attorney. Miss Love, who is the lead prosecutor on the case, says, Judge, for the reason that I specifically wanted to talk with you is that I have a concern about the representation being made of the representation of Mr. Copeland. I'm concerned, and I'm sort of not, I wanted to just bring it to the court's attention Mr. Melnick has not conveyed to either Ms. Highland or myself or any member of the state any legitimate concern that he has regarding Kenneth Copeland testifying. And again, Melnick is the attorney that was being stood in for. And there was argument going on about whether or not the prosecutors were talking to Copeland without Melnick, who represented Copeland. Love continues in the transcript, what we have seen is physical interactions with persons beside Mr. Copeland that would indicate that Mr. Copeland is not Mr. Melnick's primary priority. So the DAs are saying to the court that they think the attorney representing the witness has a conflict? Oh, God. There's nothing the DAs can do about this. If your witness has a lawyer, you don't talk to the witness without a lawyer. It goes on to say in the transcript that Miss Love is saying, what we do know is that when the fact that he's willing and wanting to leave and leave, number one, he left twice after the court ordered him to speak with his client. This is talking about the attorney. And it would seem his actions convey that it is not Mr. Copeland's best interest that is his priority. It goes on to say, Miss Hilton was out speaking with Copeland at Copeland's request at the time that I announced that Miss Hilton was calling Copeland. What I did not know is that she was trying to tell you to give us a minute because Copeland was feverishly, and I will let her speak as to how that went down, feverishly trying to get her in there to convey to her something that Mr. Melnick had just said to him that did not come from any of us. You can't talk with represented parties directly, though. The court then says, what was that, Miss Hilton? Hilton said, so let me just put the order of operation. I got up because Deputy Chief Long said, quote, he wants to talk to you, come out right now. So I went into the room. Melnick either came in or came outside. And what Copeland said was, I think that he wanted to get some autonomy. Quote, I want to talk to you. He's like, I've already talked to you, but I want to talk with her. And Mr. Melnick kept blocking him from being able to talk to me, indicating he didn't want his client to talk to the DA, like that. The DA, Hilton, goes on to say, so eventually I was like, quote, well, clearly you want to talk to him, so I'll step out and you can come in. Mr. Melnick spoke to him, and I think he was trying to eat up time because he knew that you were coming back in. So by the time I got back in there, he started to talk, and is when everyone said, come on, the judge is waiting, and that's why he stormed in angry. Miss Love said, he being Copeland, the witness. Miss Hilton said, because I think he was trying to convey to me some concerns he had, and so I was trying to have that conversation with Mr. Copeland, and I have been having really good conversations since Friday, very good conversations. So DA Hilton is having conversations with witness Copeland, seemingly from this transcript, without attorney Melnick. It goes on to say, just not even the facts of the case, but just life experiences. So I think I was building a rapport with him such that he thought I lied to him. So I was trying to explain to him, and Love cuts her off and says, and by that she means today. And Hilton says, today, about what was going to happen. And Miss Love interjected and said, because of what and then she rethought, it seems, and said, what someone conveyed to him. Miss Hilton goes on to say, we believe that something was being conveyed. What happened is, as Mr. Copeland was walking back into the courtroom, Mr. Melnick, the attorney, and Julie would have to, and I think it's Miss Langsquat, would have to confirm this, but he said, quote, they are going to hammer you. And that made me ask Miss Love, quote, did you say something about hammering him? And I don't know who. And Miss Love then interjects and says, nobody did. And the court said, it doesn't make sense that you would say that to him. And Miss Love said, we never said that. The court said, but anyways, okay. And Hilton said, so whatever that communication was, that's when he stormed in and got angry. As the result I got was that he gave when we started. So at this point, I'm very concerned. Miss Love said he, meaning Mr. Copeland, stormed in and got angry. Copeland, the witness. Miss Hilton, the other DA, said, and this is all the two DAs and the judge, to me, this sounds like talking about the case. Let me know what you think. But talking about issues with a witness is talking about a case. It goes on to say, Miss Hilton says, the timing of everything is very ironic. We laid it out on the record earlier about what happened, and I don't believe that Mr. Copeland's best interest is being served at this moment, given that, I mean, Mr. Melnick was willing to take a vacation and let him languish in jail, and that is not, we have communicated that we never wanted Mr. Copeland to go to jail. We don't want him in custody. We don't want any of that to occur. And then Miss Love cuts in and says, and Mr. Melnick has not spoken. He has not relayed. What we did get during the break was an email from Mr. Melnick. I don't know if he had people to have been blind copying someone else. The only two people I could see on the email were Miss Hilton and myself, but he referred to me in the third person and said, these are the communications between myself and Miss Love. So I asked Mr. Melnick, whose interest are you concerned about, your clients or Mr. Steele's and Mr. Shart's, SCHARDT's, two of the other defense attorneys? Because prior to this, and this is not the first time Mr. Copeland has said he doesn't represent me, this is not the first time Mr. Melnick has, and let me be real clear, when he spoke of what was happening before he represented Mr. Copeland, and then it says, and da-da-da-da-da-da-da-da. Of course, I don't know the tonality of the da-da-das, but there's a bunch of da-da-das. So the tonality of the da-da-das are my own. It goes on to say, he told me that he didn't represent Mr. Copeland. He told me, and then the court said, Mr. Melnick told you. So now the court is trying to figure out what the fuck is happening between a witness's lawyer, and the district attorneys. The DA, Miss Love, says, yes, Mr. Melnick told me previously that he wasn't representing him. From what I saw today of the hearings, the attorney, Mr. Melnick, disagrees fervently that he ever said to anyone that he wasn't representing Mr. Copeland, and is accusing the DA here of lying to the judge about that, saying that he never said any of this. So are the DAs now witnesses in this case? I don't know. Possibly. The court said you would not speak to an unrepresented party. I mean, I know you know enough of the rules to know that if you thought or intimated that somebody was represented by counsel, you would go ahead and let them contact that lawyer. And I think this says you would not speak to an unrepresented party. I can only imagine in context that meant represented party, because you literally can't. Miss Hilton said, or Miss Copeland would have said, because I don't know as a witness, because he's not charged, if he would have a right to. And Miss Love said, right. And Miss Hilton said, because he's not charged, witnesses can still have lawyers. Witnesses can still say, talk to my lawyer. In civil cases, you can still say, send it to Daryl. If you have an attorney in a case, you can opt not to speak to people and say, talk to the lawyer. It's a very 90s talk to the hand. It's talk to the lawyer. Go talk to my lawyer. So I have big concerns about whether or not Copeland was represented by Melnick at this point in time, because from all the context clues and the reading these transcripts, it seems very well that Copeland was represented by Melnick. Why? Because I read the entirety of the transcript from the June 10th hearing, which is after this June. Yes, Emily, June 10th comes after June 7th. But in the June 10th hearing, Bumpus is standing in for Melnick. First of all, an attorney's not going to call another attorney to stand in for their client if that's not their client. First. Second, what's represented by Bumpus to the judge and the DAs and everybody in that other ex-parte hearing is that if Copeland decides to testify, Melnick is terminating his representation of Copeland. But you can't terminate representation if you're not representing someone. So there are numerous instances in the official record of them talking about Melnick representing witness Copeland. And the DAs are trying to say, well, we thought that was for another case he had as a defendant. We thought that was another point in time. We didn't think that was now. Come on now. And that's part of what's going on in the hearings today and tomorrow, is whether or not the DA's office knew that Copeland was represented. Plus, what did Copeland say in these meetings? And did anything Copeland say count as Brady told to the DAs that needed to be turned over to the other defense attorneys, including Copeland saying, or allegedly saying, that he'll take all of it, including the murders involved in this RICO prosecution. It's such a mess. I don't know how you unwind this. When you talk about protecting a case from appeal, this is the extreme opposite of that. The extreme opposite of that. This is weaving the appeal in like a spider's web Gordian knot. It is just, you've woven the issues directly into the fabric from whole cloth. I keep talking to you about making things easy, and our sponsor today, Policygenius, makes one of the unfun adulting things easy. Policygenius helps you take care of your life insurance. And I know it's really easy to put things off because it feels overwhelming, or it's going to take too long, or you don't have time, or you don't know where to start. I absolutely get it, and I have been there. Policygenius was built to save time at every step of the process. They let you compare quotes from America's top insurers in just a few clicks. With Policygenius, you can find life insurance policies that start at just $292 per year for $1 million of coverage. Some options offer same-day approval and avoid unnecessary medical exams. And if you only have life insurance through work, it might not transfer with you if you choose to leave your job. So making sure you have your own policy ensures that your loved ones are covered in case something happens to you. And Policygenius has a licensed support team that is there to help you not work for the insurance companies, which is probably why they have thousands of 5-star reviews on Google and Trustpilot. Head to policygenius.com or click the link in the description to get your free life insurance quote and see how much you can save. That's policygenius.com. They go on to say that Copeland's not charged. The court said, I don't think you have to because there's no pending charges, but if he told you I got a lawyer, I don't want to talk to you, Miss Love said we would have left. But if you knew he's represented, even if he wants to talk to you, it's, I'm sorry, you're represented. No matter what you want to do, we're going to have your attorney here. The court goes on to say because people counsel that they have under retainer or something else, or they say, hey, I got a lawyer that I use for everything and I want to talk to him. I'm not comfortable talking to you unless my lawyer is present. Hilton goes on to say, we have done that with a number of our witnesses, so this would have been no different. And this communication goes on where they talk about their concerns that Attorney Melnick is not representing the best interests of Copeland, going on in this transcript to say, so I don't want to get into the facts of anything what I'm trying to get at here is the fact that Mr. Copeland, I believe Mr. Melnick has inserted himself in a way that jeopardizes the best interest of our witness. Going on to say, I believe that in conveying to the court that Miss Bumpus is going to stand in his stead. Miss Bumpus she was, what is the word I'm looking for? The sheriff had to speak to her because she was in the courtroom trying to hug Jeffrey Williams, Young Thug, one of the co-defendants. Miss Hilton said no, she hugged Deamonte Kendrick, whose motion this is we're reading now. DA Love said, I'm sorry, and Miss Hilton said, in fact, she hugged Deamonte Kendrick and hugged Mr. Williams. And that's how Captain Kendall saw her. And Captain Kendall had her taken out, presumably of the courtroom. Miss Love said she expressed dismay and concern in challenging her right to go interact in that manner with the defendants. So our concern is that it is not Mr. Copeland's best interest that are being represented, and that not only is that the case with respect to Mr. Copeland, who we have no interest in prosecuting, but that there is a tampering of sorts going on in this person inserting himself where Mr. Copeland has been reaching out to speak to Miss Hilton, and that communication is being blocked by someone Mr. Copeland didn't reach out to. And that's what the DA's office is worried about. The DA's office is telling the judge, with no defense attorneys present, that they think that Copeland's defense attorneys are inserting himself into this case to protect other defendants in the case. That's the insinuation here. That these attorneys are trying to protect Young Thug and Kendrick by telling Copeland, a witness in the case, not to testify. That's the insinuation. But if Copeland is represented and has not fired his lawyers, then the way that you deal with this is to say, Your Honor, there is some confusion about whether witness Copeland is represented by Mr. Melnick or not, and we need to put it on the record, and we need everybody in here. And you bring in everybody, and you say on the record, Your Honor, we're asking if you can inquire of Mr. Copeland, whether in our presence or not in the presence of the DA, if he is represented by Mr. Melnick. It's confusing to the DA's office. Mr. Copeland has been reaching out directly to the DA's office. Mr. Melnick says that he represents him. There seems to be a confusion here. We can't get in the middle of that because at the moment it seems that Mr. Copeland may be represented. We're asking the court to clarify it. And then the court can have a conversation with Copeland and Melnick either alone. That would be a very proper ex parte to deal with attorney-client issues, or potentially with other defense attorneys present in the courtroom, if necessary and appropriate, with the DAs out of the courtroom. It happens all the time. The moment that defendants start voicing concern about their attorneys on the record, the district attorneys in court normally go, well, this sounds like you guys need to have a hearing. Text me when you're ready. I'm gonna go now. I'm gonna just see myself out. This is not unusual. This happens all the time. So the process is not to talk to the witness. It's to clarify representation first. I interpret the DAs as insinuating that the defense attorneys are protecting the defendants and not the witness that they supposedly represent. But the argument itself highlights the issue. How are the attorneys for the witness inserting themselves if they're not his attorneys? And if they are not his attorneys, in which case it's proper for the DAs to talk to their witness, if they are not his attorneys, then how are they supposed to be looking out for his best interest? And are they witness tampering? And then that's a whole separate set of questions. But the DAs seem to say that they're inserting themselves, that they're not his client, but they also aren't looking out for his best interest. So they seem to be conflating the two issues of he's not represented, but he is represented. And if he is represented, they're not representing him right. You can't have it both ways when you've been talking to the witness. The amount of mess that this is, the amount of mess. The transcript goes on to say that Mr. Copeland had been reaching out to DA Hilton, and that communication's being blocked by someone Mr. Copeland didn't reach out to, saying, you notice no one said Mr. Copeland called me. He never said when we put on the record when Ms. Hilton said, quote, the way I understand it, Mr. Melnick reached out to Mr. Copeland, because the first time we heard an assertion like, quote, oh, he's going to plead the fifth, is when Mr. Melnick sent an email to Ms. Hilton and myself and had copied on it Mr. Steele and Mr. Shard. We're going to go with that. And had copied Mr. Steele and the other defense attorney last night. The court said, why would he have done that given? And Ms. Hilton says, and that's the state's concern. And Ms. Love says, that's the point. The court said, but here is the challenge. The challenge is you have privileged communications. And unless you've got him being the client disclosing to a third party that wouldn't be subject to privilege, that is the only way you're going to. The court is now getting into conversations about the issues here, which I think is a problem. Ms. Love says, I don't disagree with that at all. I don't disagree with that at all. But if Mr. Melnick, and the thing that got me the most is Mr. Melnick is not looking at Mr. Copeland saying, you know, Mr. Copeland, I want you to stay out of jail and I will be here with you. And if they ask you anything that touches upon something that you and I talked about, I will stand up and assert your right. He didn't do that. What he did was looked over at two people and said, like, I did what I could, and shrugged his shoulders and held his palms up of his hands like this and said, I tried. So again, the DAs are saying to the court without any other attorneys there, it seems, that Mr. Melnick is looking out for the interest of Steele's, and I think the attorney's name is pronounced Shart's, Steele and Shart's client. So they're saying in court, the attorney representing the witness is looking at the other attorneys going, what do you want? And it goes on to say, there is no reason he would be looking to the right to counsel for the defense like I tried after Mr. Copeland said he was going to testify. That doesn't make sense. The court said, well, there's a lot of innuendo that they have asserted themselves, and I think that means inserted themselves, but asserted themselves, they, being some of the defense counsel, have inserted themselves in this particular process. They are talking about the case. Ms. Love said, my concern is Mr. Melnick's insertion of himself. The court said, what are you asking me to do? What are you asking me to do? And what do you think that I can do? So the court is asking the DA what to do about an attorney that may or may not represent the witness without anyone else present. Yikes. The DA says, that is the exercise. That is the homework for tonight. I wanted to let the court know that that is what we're looking into right now because there is a remedy because I have faith in our law. I love this thing. And I know there is a remedy because this can never have been the first time this has happened. It has been addressed. I just have to find it. Oh, Georgia, what in the world? The DA goes on to say, but I don't want to be looking for something and not let the court know what I'm looking for so that you're not caught off guard Monday morning or Saturday night or Saturday afternoon when we find it and send it to you. So you're giving the court a preview of your argument on what might be a contested motion? How's that not talking about the substance of the case? Because, wow. The court said, okay. The DA says, so thank you for allowing us to audience with the court. I just want to make certain that we did it properly and we have everything on the record. It is our witness. We have conveyed to him that he is shielded from prosecution for anything that he talks about on the stand and any use of that. And that the thing is that we won't ask him that, but this is what he said, quote, y'all might not, but they might ask me some things that I have to assert my right on. And that would be on a question by question basis. What he is being influenced to do, we believe by Mr. Melnick, this is the witness's defense attorney, it seems, is, and it's through Mr. Melnick because as you saw, Kenneth Copeland said, I will testify. Mr. Melnick, even after that, said he's asserting his fifth. I'm going to go talk to him. Logically, one would think that as long as Mr. Melnick's concerns about Kenneth Copeland's freedoms, legal freedoms and his exposure, as long as those are addressed, Mr. Melnick should be saying, I am here with you. If there is something that I know will put you in jeopardy, I'll stand up and stop you. But right now, I would rather you stay out of jail. Instead, you get Mr. Copeland, and you can see through his body language, he gets there in court and he's smiling as if he's making a show of being taken into custody after this. And the man don't want to be in jail. He said it. Didn't he say he don't want to be in jail? Ms. Hilton said that's his biggest fear. Ms. Love said that's his biggest fear. And now he's in jail after Mr. Melnick asserted himself in the process. I think they mean inserted, but they keep saying asserted, but whatever. Ms. Love continues to say to the judge, so we have to figure this out. I'm not just laying this in your lap saying, go fix this. I'm just bringing it to the court's attention. This is a grave concern. But you told the court you were going to go look up law on it, and you're asking the court for a remedy. So, okay. Ms. Hilton, she's about to lose her mind because her biggest concern is that Mr. Melnick is actively harming a human being, and that's what she's maddest about. I'm mad because it is stopping our trial and it's wrong, and that is not how the law is supposed to work. So we have two big old grave concerns. I'm reading the transcript verbatim. So we have two big old grave concerns that we are working to remedy right now. The court said, okay, well, like I said, I think that you brought your concerns to me, without more. I don't know what else I can kind of do in terms of that. My comments today were predicated on there's a lot of stuff that's going on in the background, and it shouldn't have anything to do with y'all's case or you all's case. It really shouldn't, but I think it does in some way. Outside agitators, Ms. Love says that too. The court says, and everybody else I think are trying to influence. Ms. Love said that is absolutely what's happening. Ms. Hilton said there's a lot going on. Ms. Love said there is a presence. Yes, that is all I'll say. The court said, but I see it from just being in the courtroom and tracking. But okay, if you find anything, we'll see where Monday leads us. And like I said, and this is the court still talking, since we know he's going to potentially invoke, we'll just see what his pleasure is. And Miss Love says, I mean, just the idea of someone sitting in jail throughout this trial, but if that's what he's being counseled to do and that's what he does, that's just wrong. It's wrong because a member of the bar is, in my mind, creating that circumstance, you know? Miss Love, the DA, goes on to say, he's going to do what the person he trusts to have his best interest at heart tells him to do. Well, is he the lawyer or is he not the lawyer? Because if he's the lawyer, he owes a duty to the client. If he's not the lawyer, then he doesn't. Is he the lawyer or is he not the lawyer? Because in this insinuation, it sounds like he's the lawyer. He's going to do what the person he trusts to have his best interest at heart tells him to do. Doesn't that sound like he's his lawyer? He goes on to say he doesn't have to tell us what he's concerned about. He can just sit there and when he sees the train coming, stand up and say stop, but he's got a vacation to go on, so he can't be here. So Miss Bumpus is going to be here. Miss Bumpus hugging Mr. Kendrick and Mr. Williams is going to be here representing the interests of Kenneth Copeland, who is supposed to testify against Mr. Kendrick and Mr. Williams. That is where we are. That doesn't pass the smell test, says the DA to the judge. The judge says, all right, okay, and the DA says, thank you. That is the end of the rough transcript from a meeting that occurred with the DAs and the court the Friday before the meeting on Monday, June 10th, that has become such an issue in this case. I can see why defense attorney Melnick wanted to testify today after seeing this transcript where the DAs are accusing him of inserting himself into the case and almost accusing him of conspiring with the other defense attorneys for other defendants to keep a witness off the stand. That's what it seems like they're saying to the court. What a wild day in court today has been in the YSL case, and it's not done. Ms. Bumpus has testified. Mr. Melnick has testified. The defense has asked that the DAs all be recused off the case because of this. The court denied it, but this motion is ongoing, and there's conversations about whether or not witness Copeland admitted to or insinuated that he was involved in some of the murders at issue here, and whether the DAs said, we're not going to prosecute you for any of that. That is what the defense is arguing is Brady, and we're going to have to see what the court does with this. But no jury back in the YSL case August 5th, as was expected because of all of these motions. But you know who is getting ready for jury trial? Tom Girardi. Thank you for today's sponsor, Shopify, who not only hosts the Law Nerd Shop, but is kind of the reason we have a Law Nerd Shop because it was so easy to get it up and running on my own. Of course, you're familiar with Shopify. It is a global commerce platform that lets you sell no matter what stage you're in, from your first orders to 1 million orders and beyond. You can sell either in person or online or both. So I'm not surprised that they power over 10% of all e-commerce in the US, including brands you're familiar with, like Rothy's and Brooklinen, and of course, the Law Nerd Shop and your favorite nail polish. Shopify also has the internet's best converting checkout, and it really is easy to set up. But if you hit any roadblocks, their award-winning customer service is there to walk you through it. So get signed up now with a $1 per month trial at shopify.com/lawnerd, all lowercase. Go to shopify.com/lawnerd now to grow your business no matter what stage you're in. That's shopify.com/lawnerd, and you'll start hearing this sound soon. It's no wonder that businesses that grow with Shopify. Let's get back to today's episode. Speaking of Tom Girardi going to trial, that case is starting in federal court in Los Angeles. Remember, federal court's real prickly, and there will be no audio, there will be no video, there will be no streaming. We will get reports out of those sitting in the courtroom, and that is about it. This case is centered around 4 distinct clients, and Tom Girardi is being accused of stealing money from those clients through a variety of fraud counts. These are clients that are now well known of, that we have heard about, not only in things like The Housewife and The Hustler, but also extensively in the bankruptcy proceedings and in that Lion Air case in Illinois, where the court skewered Tom Girardi in a ruling about not paying clients. There are also criminal proceedings in Illinois that will be going forward after this. Tom Girardi's not the only one charged in California. His CFO is also going to be prosecuted, but that prosecution has been put over till later. One of the defenses that Tom Girardi wants to put forward is the side fraud. Remember we joked about the side piece of fraud from the CFO? The CFO is running dirty books for Girardi's law firm and then stealing money on the side. But what are you going to do if you're Tom Girardi and you find out that your accountant is stealing from you when your accountant is what seems like running two sets of books? Who do you go to? It's like, my accountant's stealing from me while I'm stealing from my clients. There's not really anywhere you can go with that. But Girardi says he didn't know and is trying to say in his defense, it seems from motions, that the CFO stealing is what took the money from the clients. And so the state's attorneys, as they're wont to do, said, oh, no, sir. Oh, no, nay, if you will. The problem's not the CFO. Don't worry. We're coming for him too. The problem is and this is what's in the government motions, the problem is the $25 million that Girardi Keese funneled into Erica Girardi's entertainment career. So the jury questionnaire has numerous questions about Bravo, celebrity gossip, Erica Jane, Erica Girardi, what the jurors watch regarding that, what podcasts they listen to, if they listen to other streaming entertainment. Never once does it say YouTube specifically anywhere. Eventually they'll catch on that YouTube is something that should be asked about specifically, not just do you watch TV. But the prosecution is going to show that money went to Erica Girardi from the law firm to show that that money he was taking from clients was supporting his, say it with me, lavish lifestyle, not that it was money that was being embezzled by the CFO. That's the way that Erica Girardi is coming up in this case, and wouldn't have if the defense wasn't putting forward this side fraud as being the problem, because the prosecution has to head that off. So we are going to look real quickly at the prosecution's statement of the case. Again, we know of these victims. We know the stories of these cases. I have been covering them since 2020 in the bankruptcy side. We have seen them in The Housewife and The Hustler Part 1 and 2. These are not new stories. These are not new victims of Tom Girardi. These are things that were also really well documented in the state bar disbarment proceedings, wherein Tom Girardi was disbarred. So the prosecution just needs to show it to the jury and see what they decide, because a lot of these facts are already really well established, and Girardi's going to try to say, I wasn't stealing, the CFO was stealing. So this is the government's, or part of the government's trial memorandum. Their statement of the charges is this: Defendant Thomas Vincent Girardi is charged in the indictment with a scheme to defraud former clients of the Girardi Keese law firm through the misappropriation of settlement funds in a fraud scheme dating back to at least 2010. Yes, there is more than that, but that is a lot beyond the statute of limitations. So we know that these things go back decades beyond. This is what's in this prosecution. The government's case focuses on 4 client victims that are identified in the indictment. Summary of the scheme to defraud. Defendant Girardi's scheme involved the years-long misappropriation and embezzlement of millions of dollars from client trust accounts at the former law firm Girardi Keese. Specifically, the scheme involved defendant Girardi stealing millions of dollars in client settlement funds and failing to pay Girardi Keese clients the money that was due to them. In carrying out this scheme, defendant provided a litany of false excuses for failure to pay clients, and co-defendant Cayman, the CFO, aided and abetted the scheme by transferring client funds at defendant Girardi's discretion to pay previously defrauded clients or other unrelated expenditures. The scheme involved, among other things, the 4 client matters below, and that it lists the different client cases, including the Rigomez cases, a Havasu boat crash case, a Lake Castaic case, and others. They go on to say that there were illegitimate expenses and evidence of misappropriation during the time frame as the charged conduct in this case. Defendant Girardi diverted tens of millions of dollars from the Girardi Keese operating account to pay illegitimate expenses, including over $25 million to pay the expenses of EJ Global, a company formed by his spouse related to her entertainment career, as well as spend millions of dollars of Girardi Keese funds on private jet travel, jewelry, luxury cars, expensive golf, and social clubs. Meanwhile, co-defendant Cayman, the CFO, was separately, unbeknownst to defendant Girardi, funneling millions of dollars from the Girardi Keys operating accounts to accounts that he controlled for his own personal enrichment, the side piece fraud. At the end of 2020, as defendant and his law firm faced mounting legal problems related to his years-long theft of funds, Girardi Keys was forced into involuntary bankruptcy. The case then lays out the wire fraud elements and the embezzlement, says that the trial is estimated to take 5 to 7 days for the case in chief of the government, and then the parties will take no more than 12 court days total, jury selection, defense, and everything. They've listed the witnesses as Joseph Rugomez, Kathleen Rugomez, and Kimberly Archie. You will recognize them from The Housewife and The Hustler Part 1. Kim Corey, Judy Selberg, Eric Suthi, Alexa Galloway, Norina Ruland, Josefina Hernandez, and others. And then an IRS special agent and a doctor's on the list. So you will really see in this trial everything that we know from the bankruptcy coming forward and not much more. They go through the stipulations for the records. It seems that the prosecution and defense have stipulated that all the records from the bankruptcy can come in. The prosecution does take a minute to complain about discovery in their motion, saying that on July 27th, 2024, defendant Girardi produced voluminous discovery. This is like a week before trial, totaling 50,000 pages to the government pursuant the government's demands for reciprocal discovery, to which it was entitled under Rule 16b and 26.2 of the federal rules. This production, roughly a week before trial, does not identify any specific exhibits that the defendant seeks to use and amounts to a data dump and does little to ensure that the trial focuses on the matters related to the charges in the case. So the prosecution's going to be arguing to keep out a lot of this data dump, and the defense is like, we turned it over, and the prosecution's like, no, you don't. And then the prosecution summarizes the defenses that they expect. Number one, defendant Girardi's cognitive impairment. They say the issue of defendant's mental status has been extensively litigated in this case. The court's pretrial rulings on the testimony of Dr. Chu and Dr. Darby regarding defendant's mental state and the admissibility of his post-scheme mental condition have limited the scope of any such testimony. How he is doing now is going to be very limited because what he did in the past, there's no evidence of impairment there. And the defendant's behavior of trying to cover what he was doing indicates that he was aware that he didn't want to be caught. It goes on to say any mental condition evidence that falls outside that scope or addresses other aspects of the trial or the defendant's character should be excluded. They talk about evidence of Cayman's side fraud scheme and how that should be kept out, other than really that Girardi didn't know and keep his employees from also stealing from clients. They talk about attempts at post-theft mitigation, but that's not a defense to wire fraud. So anything Girardi tried to do later doesn't matter once the theft happens. So if you steal from the client and then try to backfill it with other monies is not a defense to wire fraud. And at the June 20 motions hearing, counsel for defendant Girardi acknowledged that, quote, Girardi had significant amounts of his own personal money swimming around in these trust accounts. What a mess. What an absolute mess. And we've seen that in other arguments too, that Girardi had intermingled all of these funds. They anticipate a victim negligence defense from Girardi and are arguing to the court that that's not an appropriate defense, saying any attempt by Girardi to fault his clients for delayed payment of settlements should be excluded. For example, the defendant sent several lulling letters, so telling the clients that things weren't handled and that things weren't taken care of and that, taxes need to be handled and I've got this and I'm taking care of it for you. None of that should come up to fault the client for not more aggressively going after the funds. And the prosecution is trying to head off that defense before it even gets rolling. I don't think trying to blame the clients is a solid strategy in this case, especially given everything we know about Girardi's lifestyle. And then they summarize all the exhibits and the witnesses. But again, we know that this case is going to center around the clients that didn't get paid. And the clients are going to get up there and testify that they didn't get paid. and what their settlements were and what he said to them, what the emails said, what the voicemails said, what their conversations said. So yes, it'll be the first time really hearing from those witnesses under oath, but things that we have seen in documents and in case filings and in other cases for over 4 years now, if not longer. So Tom Girardi is going to trial. It will be a quick one. I will keep you in the loop on that in the Law Nerd app. And with that, thank you for being here. Thank you for being a Law Nerd. Lots going on in the courts these days, and you want to make sure again that you have that Law Nerd app to stay in the loop with all the live streams. And I will see you soon. So raise your Law Nerd tumbler. May your family be well. May your Wi-Fi be strong. May your toilet paper be plentiful. And may the odds be ever in your favor. Emily, did you say that in totally the wrong order? I did, but that's okay. Because I appreciate you being here and thank you for being a Law Nerd. I'll see you in the next one. You can stay up to date with everything I'm covering on our free iOS and Android app at lawnerdapp.com or search your app store for Law Nerd. And you can also follow me on social media at the Emily D. Baker. Remember, I stream on YouTube on Tuesdays and Thursdays. I recap all of that for you in quick bits on Monday. And of course, the Emily Show drops on Wednesdays. Thanks for being a Law Nerd.